Good afternoon, everyone. My name is Dan Stanton. I'm the Government Information Librarian here at Arizona State University. And I'd like to welcome you to our 2013 Constitution Day celebration. Before we begin, I'd like to let you know about a couple of related events. On level 3 of Hayden Library, we have a government document display about the history of voting rights, and you have a little teaser here in the back, and please feel free to help yourself with some swag back there. There's some pocket constitutions, pencils, which every good student needs, and information about some of our federal resources. Voter Registration Day will be held Tuesday on September 24th. The ASU undergraduate student government will be on Hayden Lawn from 10 a.m. to 2 p.m. to register voters, and we'll have a bounce house and music. So please be there. And a big thank you to Amy Umaretia of the undergraduate student government for her assistance in promoting this event. And thanks to Brad Vogus for his support, and to Lindsay O'Neill for her work on the display and promotion, and to Jenny Duvernay for her assistance with marketing and promotion. Welcome to Constitution Day 2013. Constitution Day commemorates the formation and signing of the U.S. Constitution on September 17, 1787. This year's program asks, how long have you had the right to vote? The answer may surprise you. Is voting a conditional right? If so, how far afield can these conditions go? To help us understand, I'm very pleased to introduce Dr. T.J. Davis, Professor of History at Arizona State University. In addition, Dr. Davis is an attorney admitted to practice law in Arizona and New York. He specializes in U.S. constitutional, legal, and economic history, and he is a leading scholar on race in U.S. law and on African American history, and, as this is a three-peat for him, a friend of ASU Library's Constitution Day. We are very fortunate to have him at ASU and very pleased to have him speaking with us today. Dr. Davis.
Thank you very much. I thank the university libraries and student government for asking me to be here. I'm delighted to be here to answer Mr. Stanton's questions. A, not long, and B, maybe surprising. But happy Constitution Day. Happy Constitution Day.
Thank you.
Thank you. On 17th September 1787, 226 years ago today, a federal constitutional convention of 29 delegates, deliberating since 25 May, adopted and transmitted to the United States and Congress assembled a freshly drafted document the delegates described as that Constitution which appears to us most advisable. And that's what I'm going to talk to you about today. And I've titled my remarks, Back from Shelby County. As I'll explain, Shelby County is a June this year, 2013, decision of the Supreme Court of the United States. So back from Shelby County, racism, federalism, exclusivism, and the continuing struggle over the right to vote in America. At least a couple of my students are here, so they know I like triads. So we've got racism, federalism, and exclusivism. I probably will mention those again. 9 of the 13 states ratified the document by June 1788, and it went into effect on the 4th of March, 1789. On 30 April 1789, in the city of New York, the Virginian George Washington, patriot hero of the War for U.S. independence, took the constitutionally prescribed oath of office to become the first president of the United States under the Constitution of 1787. No popular voting installed Washington. Indeed, popular voting was then a more than debatable political proposition, as it has ever since been. On 25 June 2013, the Supreme Court of the United States refueled the long-heated contention. In the case of Shelby County v. Holder, the court held unconstitutional provisions of Section 4B of the Voting Rights Act of 1965. The 5-4 decision essentially undid the historical and historic civil rights measure. Writing for the 5-4 majority, Chief Justice John G. Roberts acknowledged that the law originally, quote, was needed to address entrenched racial discrimination in voting. He quoted the court's 1966 decision in South Carolina v. Katzenbach that upheld the landmark 1965 Act in addressing an insidious and pervasive evil which has been perpetuated in certain parts of our country through unremitting and ingenious defiance of the Constitution. The court there unanimously upheld the act, although then 80-year-old Justice Hugo Black of Alabama dissented against the so-called pre-clearance provision that the court majority found problematic in Shelby County v. Holder. The court's decision in Shelby County reflected the historic conflagration over voting rights in the United States. Three major streams have sustained the burning issue. One has been racism that elevates whites and suppresses people of color, most historically, blacks. A second has been federalism, with its ever-contested division of authority between federal and state government. The third has been persistent exclusivism, as groups seek to arrogate to themselves rights, property, and privileges they hold to be theirs alone, and from which they seek to exclude all others. Such groups and their individual members have held themselves alone entitled to or eligible for the object of their desire. They view themselves alone as deserving or otherwise being worthy. They cast themselves alone as understanding and cherishing the true value of whatever would be their focus, such as the right to vote. Such exclusivism is older than the United States, although the American majority has sought usually to silence the theme in the nation's typical rhetoric. On the right to vote, the three streams have converged in three questions. Who should vote? On what should the right to vote rest? And who should decide who should vote? On what basis? American political rhetoric has come to hold that, as U.S. Supreme Court Justice Hugo Black declared in 1964, no right is more precious in a free country than that of having a voice in the election of those who make the laws under which, as good citizens, we must live. Other rights, even the most basic, are illusory if the right to vote is undermined. If, in truth, the development of Anglo-American policies and practices in the United States have honored the principle Justice Black enunciated, then also, in truth, history has shown brutal disagreement in America over who should hold or exercise the right to vote. Many have sought to cast the right to vote in America as inexorably expanding and extending along some triumphal march of liberty. But the grant and exercise of the right has been, if anything, more of an ebb and flow. The tide has not been unidirectional. Retreats have marred whatever long march history has revealed. Getting, holding, and exercising the right to vote has been a continuing struggle throughout U.S. history. Belief in participatory democracy has never extended so far in America as to embrace as law universal suffrage for all adult citizens. Indeed, the idea of entitling and allowing every adult citizen to vote has persistently horrified more than a few Americans. New York's prominent conservative jurist, Chancellor James Kent, articulated a view of the perennially rebuked horrors at the state's 1821 Constitutional Convention. Quote, "The tendency of universal suffrage is to jeopardize the right of property and the principles of liberty," he asserted. Voting, in Kent's view, was a right suited for some, not all. It was a right best invested in the few, not the many. Contention over voting rights in America long predated Chancellor Kent's comments or even the U.S. Constitution. And since its inauguration in 1789, no theme has appeared more frequently in constitutional amendments than voting rights. Now, my students need now to get out their outline to see if they've caught all the provisions. Here we go. Got Amendment 14, right? Providing for a right to vote for males over 21 years. Got Amendment 15, providing that neither race, color, or previous condition of servitude can be a bar to the right to vote. You've got Amendment 17, providing for direct popular election of senators. Amendment 19, providing that sex is no bar to the right to vote. Amendment 23, providing that residents of the District of Columbia had the right to vote in presidential elections. And you have Amendment 26, providing that those who have reached the age of 18 may not be barred by age from the right to vote. All those treat the right to vote in federal elections. The Constitution of 1789 glossed over the right to vote, to put it mildly. It provided simply in Article 1, Section 2, that the House of Representatives shall be composed of members chosen every second year by the people of the several states, and the electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislature. Who among the people got to choose, and the method by which the chosen people got to choose, were left to the states to determine. Indeed, the qualifications requisite for electors remained wholly within the direction of the states, each deciding as its legislators thought best. The U.S. Supreme Court, in its ruling in Bush v. Gore, 2000, at least some of us in the room reach back that far to remember the decision. It might have been important in U.S. history, considering what happened thereafter. But then again, maybe not, considering what has happened since then. Bush v. Gore emphasized that, quote, "The individual citizen has no federal constitutional right to vote in presidential elections." Let me repeat that quote. It may be surprising to you. This is the Supreme Court of the United States. The individual citizen has no federal constitutional right to vote in presidential elections. For how many of you is that a surprise? Okay. The per curiam 5-4 opinion of the majority explained, quote, "The state legislature's power to select the manner of appointing electors is plenary. It may, if it so chooses, select the electors itself." And most Americans don't recognize that in few states do they actually ever vote directly for the president. They vote rather for presidential electors. And in a state like Arizona, you get to see that because the names of those who are to be electors are listed on the ballot along with the name of the candidate. But I expect that many people look at that and say, who are those folks? I know who the candidate is, and that's what I'm filling in my little box for. We used to say pull the lever, but who in the room has actually pulled the lever other than me? Anyway. Commentators have suggested the Constitution's command in Article 4, Section 4, that states maintain a republican form of government, at least implied a popular right to vote. Such an interpretation has turned solely on the meaning of Republican. That's with a large R. That's not Mr. Boehner's party or Mr. McCain's party. That's Republican as in the theory. Accepting the guarantee clause as a reiteration of the principle of popular sovereignty, as enunciated in the 1776 Declaration of Independence, and echoed in the Constitution's opening words, "We the people," has left unsettled who among the people held whatever right the clause may have conferred. The U.S. Supreme Court in 1874 dismissed any claim that the guarantee clause conferred or implied any right of suffrage in any group of citizens. From the nation's beginning, the court noted, all the citizens of the states were not invested with the right of suffrage. Moreover, the court reiterated that it recognized no claim to contend that a government is not Republican within the meaning of this guarantee in the Constitution because a group of citizens, such as women, are not made voters. The framers of the Constitution in 1787 agreed on the necessity of some popular election of federal office holders. Yet, at the Constitutional Convention and thereafter, the framers themselves disagreed bitterly on which offices should be elected directly by popular vote and who within the populace should have a vote. The Constitution provided only for members of the House of Representatives to be directly elected by the people, by popular vote. It provided no popular vote to elect members of the Senate of the United States, nor the President or the Vice President. Yet the U.S. Supreme Court noted in 1983 in Anderson v. Celebrezzi, quote, "The President and Vice President of the United States are the only elected officials who represent all the voters in the nation." Now you wonder how they reached that conclusion when the President is not in fact elected by popular vote. But actually, if you examine the proposition, we Americans never vote outside of state lines. There's only one national office that we collectively elect, and that is the President and, of course, the Vice President. The splitting of federal legislative powers into branches represented in large measure a compromise on the issue of popular voting and state sovereignty. The clash more pointedly pitted a conglomerated popular sovereignty against individual state sovereignty. New Jersey, in its 1787 Constitutional Convention, sharply expressed the tension in the words of Delegate William Patterson. Quote, "If the sovereignty of the states is to be maintained, the representatives in Congress must be drawn immediately from the states, not the people." Maryland Delegate Luther Martin further revealed the fear of agglomerated popular votes beyond states. He worried that simply tallying popular votes would allow more populous states to dictate policy everywhere. He likened such a result to slavery. And whenever I hear comments like that, I always wonder what white men such as Luther Martin thought slavery was, but he had his own view, which was a view different from someone like Frederick Douglass, a black man who had been a slave, or Sojourner Truth, or Harriet Tubman, black women who had actually been slaves. Luther Martin said, "The states, being equal, cannot treat or confederate so as to give up an equality of votes without giving up their liberty." Such a result meant to Martin, quote, "a system of slavery for 10 states. He explained that Virginia, Massachusetts, and Pennsylvania together then contained a majority, well, not quite a majority, about 47% of the population of the 13 states. So he went on to say, Virginia, Massachusetts, and Pennsylvania have 42 of 90 seconds of the votes, and they can do as they please without a miraculous union of the other 10 states. That they will have nothing to do but to gain over one of the 10 to make them complete masters of the rest." And that's a question that we Americans continually must struggle with. The degree to which we want independent communities or the degree to which we want national communities. I mean, we have a neighboring state, California, and you know they say mean things about us. They call us zonies and things of that sort. But presently, about 1 in 10 of every Americans resides in California. So should California have 1/10 or 10% of the say on all policies, and the rest of the 49 states have to divvy up the remaining 90%? How should that work? Well, the compromise of adopting a bicameral legislature and keeping all popular voting in federal elections within state lines became the core of the great compromise that produced the Constitution of 1787. It did not settle fears about popular voting. It did at least indirectly identify classes and groups of persons to be counted in popular and electoral representation. The infamous 3/5 clause of Article 1, Section 2 divided the people into the whole number of free persons, including those bound to service for a term of years, and excluding Indians not taxed, and 3/5 of all other persons. Delightful progress has been made on voting rights since the nation's beginning. That progress has come, however, amid stubborn contention relating back long before the U.S. Constitution began operating in 1789. And the gains have not necessarily persisted. The unenfranchised have always been numerous. Indeed, throughout American history, the unenfranchised have long easily constituted the silenced popular majority. And when nominally enfranchised, many constituting local majorities or sizable minorities has suffered illegal and legal disfranchisement by what the landmark Voting Rights Act of 1965 would describe as tests and devices. The experience of blacks, Indians, Mexican Americans, women, and many non-English speakers has amply attested to that proposition. Before the U.S. Declaration of Independence in 1776, statutory qualifications for voting in the British colonies of North America that would constitute the new American nation restricted the right to vote exclusively to property holders. That based voting on a class of wealth. The constitution of certain colonial societies, such as those in New England, with Massachusetts Bay being most prominent, also at least implied a religious test for voting. The first generation in Massachusetts Bay, where the settlers arrived en masse in the 1630s, came as members of a homogeneous community. They came as full-fledged Puritans, and participation in communal life and politics rested on membership in their congregational churches. Simple demography created a crisis within less than 2 generations as the population expanded beyond church membership. The so-called Halfway Covenant of 1662 sought to readjust church membership and with it the right to vote on civil matters. It was no solution for the female majority of the population. Gender dominated qualifications for voting and participation in politics and other public affairs. Women were routinely banned and remained without the right to vote nationally until the Constitution's 19th Amendment in 1920. Simply like their British forebears, colonial Americans restricted the right to vote to adult, white, male property holders. For race also marked voter qualifications. The ringing words of the Declaration of Independence that governments are instituted among men, deriving their just powers from the consent of the governed, resounded in no immediate wholesale change in the basis of the right to vote in America. Yet slowly, but with growing momentum, the weight of propertyless white men wedged their entry into the right to vote. So-called Jacksonian Democracy advanced the movement beyond Andrew Jackson's presidency from 1829 to 1837. By 1840, only 3 states, Rhode Island, Virginia, and North Carolina, retained property qualifications for voting. In 1856, North Carolina became the last of the states to yield. While moving from casting property holders alone as stakeholders eligible to vote, many states in qualifying voters clung to some wealth standard, yet nothing more than paying taxes. And here I ask you to consider a question. To what, if any, degree should the right to vote depend on how many taxes you pay or whether you pay taxes at all? Is the right to vote based on something else? Or is it contingent on something such as paying taxes? By 1855, only 6 states insisted on tax paying as a qualification to vote. Even so, paupers almost routinely and universally lost any right to vote. And we can see a similar campaign today, or a similar act of disbarment, where if you don't have a fixed residence, when you go to register to vote, you cannot register to vote. You must have a fixed residence to which the registrars can send your voter registration. So if you're homeless, and that is a property issue, isn't it? You can't register to vote. And of course, if you can't register, you can't vote. So the shift from property was a shift primarily from the qualification of landholder. In part, it reflected a shift in an expanding industrial and urban economy away from land as a primary indicator of income and wealth, but it hasn't gone away. At the outbreak of the Civil War in April 1861, gender and race loomed as the most salient disqualifications for adult U.S. citizens seeking to vote. Before 1807, New Jersey alone permitted women to vote. Anyone here from New Jersey? Well, let's give a shout out to New Jersey. The exclusion ranked among the primary complaints of the historic Declaration of Sentiments and Resolutions of the Women's Rights Convention held at Seneca Falls, New York on 19 and 20 July 1848. The convention resolved that it is the duty of women of this country to secure to themselves their sacred right to the elective franchise. The duty would not be legally recognized in the nation for another 72 years. The spotty trend on black voting in antebellum America turned mostly negative. Maine, Massachusetts, New Hampshire, and Vermont alone allowed unfettered black voting. But they had hardly any black population. Even by 1860, Massachusetts had only 4,469 black males. Maine had 659. Vermont had 371. New Hampshire had 253. And that was counting black males of all ages. Now, at least 42% of those were younger than 21 years of age and thus would not be eligible to vote. So by 1840, barely 7 of every 100 blacks north of the Mason-Dixon line lived in a state that allowed blacks to vote. And in a place such as New York that allowed black men to vote, the law required separate and more stringent qualifications. South of the Mason-Dixon line, black voting became even more exceptional. Parts of North Carolina and Tennessee allowed blacks to vote before 1835. So did parts of Louisiana from 1838 to 1860. But there it was Creoles of color, the property gens de couleur, the free people of color, mostly but not exclusively in New Orleans, who exercised that suffrage. And while they were counted as non-whites, they were hardly counted as blacks. Mass black voting in the United States resulted from the Civil War. More accurately, it resulted from the Civil War's wake, described as Reconstruction, the years from 1865 to 1877. when ex-Confederate states completed a mostly congressionally directed process to resume representation in Congress and state self-government. Congress provided in January 1867 for black male suffrage in the territories. It declared that thenceforth there shall be no denial of the elective franchise in any of the territories of the United States, now or hereafter to be organized, to any citizen thereof on account of race, color, or previous condition of servitude. In the first Reconstruction Act in March 1867, Congress more pointedly established universal adult male suffrage. Black voting emerged as an element of the American foundational concepts the Civil War altered. In outlawing slavery by the 13th Amendment at the Civil War's end, the United States, wittingly or not, enlarged an attack on enforced civil, economic, and political dependence. The false notion that voting rights arose as a national issue only with the end of slavery in 1865, or that it remained predominantly a black issue, has distorted American history and practice. True enough, a powerful, persistent spotlight on problems related to voting rights and discrimination in America has flared from the heat of black struggle for U.S. law to bar race as a qualification for voting, and then to outlaw what was the essential element of the Voting Rights Act of 1865. The voting rights struggle against discrimination on the basis of immutable personal characteristics never engaged only blacks, nor advanced blacks' interests alone. The long argument over women's rights to vote ran in concert with blacks' voting rights, and both joined in their choir railing against exclusive white male privilege. While sex remained constitutionally valid as a voter qualification following the decision in Minor v. Happersett in 1874, race, color, and previous condition of servitude, the focus of the 15th Amendment, became a key issue from the 1870s on. White Southerners were hardly alone in resisting blacks voting. White New Yorkers in 1869, for example, voted down a statewide referendum to grant black men the right to vote on the same basis as white men. And the New York vote was broadly illustrative. 14 other states and their territories outside the South rejected black voting between 1863 and 1870. Yet it was chiefly in the South, where the bulk of blacks resided, that resistance to black voting turned bloody. Congress responded with what has been referred to variously as the Civil Rights Act of 1871, the Enforcement Act of 1871, or the Ku Klux Klan Act of 1871. The legislation recognized and outlawed unlawful combinations or conspiracies to obstruct voting. And that indeed is the heart of what the Voting Rights Act of 1965 sought to do. Because from the 1880s to the 1930s, following what's called the Mississippi Plan, states created various tests and devices, as the Supreme Court puts it, to bar blacks from voting through devices such as the grandfather clause, literacy clauses, cumulative poll tax clauses, or poll tax being a tax that you must pay to vote. And a cumulative poll tax said that the first day you were eligible to vote, the tax began to accrue. So when you turned 21, your tax began to accrue. And let's say, for whatever reason, you were a sailor sailing the ocean free, and you didn't get home to vote until you were 35, you had 14 years of poll taxes to pay before you could be eligible to vote. In addition, if we look at something such as the so-called progressive movement, where the press to restrict the right to vote to the right people meant continued disfranchisement, not for blacks alone, but for many with them. Devices such as the all-white primary, in which the Democratic Party particularly described itself as a private club to which it alone could decide on membership, was used to essentially eviscerate the quality of blacks voting, because while blacks could then vote in the general election if they could get by the state qualifications, the winner of the campaign had already been selected. It's like voting the day after the polls have closed, which is to say that's not voting at all. The Voting Rights Act of 1965 cast back an eye on the various tests and devices, the various ruses used by states to deny voting to blacks and to other groups, persons of color, other minorities, so that the right to vote could be exclusive, so that the right to vote could be maintained by those who thought themselves alone entitled to the right to vote, because they alone understood and cherished the right to vote, because they were going to vote the right way. It's important to vote the right way, but the issue there is who decides what the right way to vote is? Well, that's easy. If you vote the way I vote, then you voted the right way, and all is good. And so, with the Supreme Court's Shelby County decision, the United States returns from whence it came. The heated contention over voting rights continues. The court majority conceded that, as Justice Ruth Bader Ginsburg's dissent emphasized, quote, voting discrimination still exists. No one doubts that. Joined by Justices Stephen Breyer, Sonia Sotomayor, and Elena Kagan, Justice Ginsburg continued to declare that with the majority's decision, quote, the court today terminates the remedy that proved to be best suited to block that discrimination. Justice Ginsburg explained further that the evolution of voting discrimination into more subtle second-generation barriers is powerful evidence that a remedy as effective as plea clearance remains vital to protect minority voting rights and prevent backsliding. Thanks to the Voting Rights Act, progress once the subject of a dream has been achieved and continues to be made, Justice Ginsburg concluded. The dream remains for some. For some, it has ever been a nightmare. Allowing all of we the people to vote, even in the American nation that declared itself founded on the principle of governments deriving their power from the consent of the governed, the central issue remains, as ever, whether the nation's public policy should aim to get as many people as possible to vote or to keep as many people as possible from voting. Advocates on both sides of the question cry abuse. Some cry that people are voting who should not vote. Others cry that people are not voting who should vote. The issue is perennial. It's not going away. Every generation of Americans appears destined to settle the issue for itself. And for some generations, such as mine, and I hope for those of you coming of age, for yours also, the issue will be settled one way and then another over time, and perhaps more than once. Remembering that Constitution Day is also Citizenship Day, and remembering also that citizenship conveys both rights and responsibilities, all of us must shoulder the responsibility of engaging the question of voting rights, not merely by debating or attending lectures, but by exercising the right to vote and moving others also to exercise the right to vote. Thank you. Be happy to entertain questions. Please.
So the Voting Rights Act of 1870, correct? This decision got rid of a certain provision where, from what I understand, the states that were involved were required to seek approval from the federal government anytime they changed anything about where they were doing their polling places, whether they were doing like removing like deceased or people that have moved away from their ballots. That almost seems now 130, 40 years later, people that didn't perpetrate these crimes against people, discriminating against their voting rights. That almost seems like they're still paying, or it's almost like a what is that? One of those continuing. It's in the Constitution where you're not allowed to punish their bloodline. It almost seems like a punishment, a bloodline punishment, that these states are continuing to have to do this where other states are not. So it almost seems like a states' equality rights issue where, say, Arizona doesn't have to notify and seek approval from the government, from the federal government, when they move their polling places or they remove people from the ballots, but these other states do. Can you comment on that? How does that fit into this decision?
Well, back to the triad that I offered: racism, federalism, and exclusivism. So you speak to the exclusivism provision, which Justice Black spoke to, and to which the majority in Shelby County spoke. So some of what you said is on point. Some sort of garble the historical facts. There are some states who, because of the history of their repeated violations, are held to standards that not all other states are immediately held to. But what you should understand is that all the states are held to the same standard. The issue, as you put it, is a pre-clearance issue. So what we have here is essentially a case of what do you do with recidivists? If you have people who essentially repeat the same actions over time, should you have them on probation? So the bottom line to your question, sir, as I see it, and the bottom line as the majority in Shelby County saw it, was that, well, we are agreed that the measure should be temporary. So how long is temporary? When you look at the pre-clearance provisions, what you should understand is that since they were put in place in 1965, they have been reissued regularly now 4 times, right? So they come up periodically for a vote. So in the Congress of the United States. So the degree to which states continue to be held liable is the degree to which they have not demonstrated that they're not liable, as Justice Ginsburg put it, to backslide. So the question in part is, when do you get off probation? And you get off probation when you've demonstrated that you've followed the straight and narrow path. But you mentioned Arizona in your comments. Arizona has been held to task under the 1965 Voting Rights Act, for example, in providing ballots in multiple languages, okay? Because one of the things people sometimes do not understand is that they're eligible to receive a ballot in a language in which they are literate. So if you are a speaker of Urdu, you can request that the Maricopa County Registrar produce a ballot for you in Urdu. And if the registrar refuses to do that, you have a federal complaint and can sue thereon. And New York has been sued on that. California has been sued on that. Arizona has been sued on that. So you're right to suggest that those old states that form the Confederacy remain outliers. Part of the question is, do they remain outliers by their own doing, or have they simply been ostracized because somehow there's animus against them? And I leave that to you to answer as you see the filters working out. Please.
Do you know when the last time was that one of the states that did fall under the voting rights pre-clearance thing actually had one of their laws struck down because of it?
This is 13. The answer is that I don't know offhand, but I think it was 2008. All exhaustive questions. Please.
I believe there's currently a controversy regarding Arizona's proposed mandate of the use of the state voter registration form versus the federal voter registration form.
No longer, the court struck that down.
But I understood that the Secretary of State in the state of Arizona was going to appeal and attempt to mandate the use of the state process and requirement for voter ID.
They may in fact do that, but at this moment, the law is that that is not allowed. Arizona is not allowed to do that.
I was going to ask, in terms of the portion that was struck down by the Supreme Court, wasn't some of the argument that it had not been renewed as recently as it should have been in terms of it being relevant to now?
Well, I think, Mr. Stanton, the issue is not that it hadn't been reviewed or renewed. The fact was that it was renewed, and the present provision is to run until 2031, or it was before the court acted, to run until 2031. And folks were looking out and saying, well, that's way distant. If there was a renewal, it should have been for a 5-year period, not for a 20-year period. Please.
There's like a big brouhaha in North Carolina, I can't remember which one, about they're cutting down like the early voting days, which I understand because a lot of people in the area, many blacks, like choose to vote before the voting days. I understand that, but they're also talking about making voter IDs mandatory, and I don't understand the problem with making voter IDs mandatory.
Well, Ms. Brasha, how can I put this simply? The question is, what should the ID be, right? When should you have to produce the ID? Which is to say that when I go to register to vote, if you require that I bring certain things with me to register to vote, okay, right? But once I've done that, on the day to cast my ballot, should I need to do that? Should I need to bring that full panoply of ID with me? And then the other part is, what should the ID be? Should it be, does it have to be a photo ID? Does it have to be a government issued photo ID? What happens then for the persons in the room, particularly students, who have changed addresses so that the address that appears on your driver's license, for example, is not your current address? Should that somehow disqualify you from voting on the day you go down? So the problem is the form, the requirement on the day that you vote, and part of it also, from my perspective, is equalizing the elements. If I vote by early ballot, right, a month before voting day, or actually I guess it's 60 days before voting day, the registrar sends out a little notice saying, you know, if you've changed your residence or whatever, or if we had to forward this, or if it came back, you've got to notify us so that we can send you your early ballot, and then you get your early ballot, you check it off, you put it in the mail. Well, if I'm sitting at home or in my office, I don't show any ID or anything else. But if I choose not to exercise that mode of voting, then I get in the car and I go down to the polls and someone says, well, let me see your state driver's license. Well, I'm not a driver. I didn't drive. My spouse drove me and dropped me off. Well, sorry, you can't vote. So there's a difficulty there. But aside from that, people who press the ID at the polls issue essentially, in my mind, want to suppress voting on the basis that abuse is going to take place, because all these people are going to flood into the polls who aren't eligible to vote, and they're going to change the outcome of the election. Okay. Abuse goes on. There are some people who vote who, quote, shouldn't vote, right? They're not eligible to vote. All the studies that we have, longitudinal studies over long periods of time, indicate that it's never 2% of the vote cast. So part of the question, which I hope I suggested in my remarks, is what should public policy be? Should we be about suppressing the right to vote, keeping people from voting because we're afraid that 2 out of every 100 or 17 out of every 1,000 votes cast are going to be improperly cast? Or should we be more concerned with the 983 who we got to the polls? And the bottom line is that if all the persons in America who were citizens of the United States, 18 years of age or older, went out to the polls, we'd have a radically different political system. You know, all the people who've given up on voting because they've been suppressed, discouraged, whatever, it does not resound well with that phrase I quoted several times from the Declaration of Independence, that governments derive their just powers from the consent of the governed. Because we've got these people who are governed, but who either don't have a voice or are not exercising their voice. Of course, one could say if they're not exercising their voice by choice, that is their choice. But choices are sometimes foisted on us by circumstances, events, and evil doing that we would not otherwise make if left to our own devices. Come on, one last question. So we can all, please.
Perfect. I was trying to think because I had a comment, but I'd rather frame it as a question. And then it's kind of a speculative one. Because I think that a lot of the issues surrounding barriers for people participating, people that are disenfranchised, many of them are economic. I mean, just about anything that you can list off as a form of ID could be an economic barrier to somebody. You already mentioned a stable address in order to register to vote. If you have an electric bill, even a driver's license or a state ID costs money to get and takes time to get there and get that. So speculation, what possible way could we, in an ideal world, how could we make it so that people could, everybody who's eligible to vote, all adults, how could we make it so that they can vote?
Okay, an easy solution is that when the baby is born and gets her birth certificate, she's thereby registered in the rolls, and on and after her 18th birthday, all she has to do is walk down to the polls and vote. If you don't like that part, all she has to do then is walk down to the registrar and say, hey, remember me, 18 years ago, whenever it was, I was born here, I'm a citizen of the United States, and I'm now registering to vote. I get my mail at whatever, or I don't get any mail, and I go on about my business. And moving from those who have birthright citizenship to those who are naturalized, on the date that you're naturalized, you're thereby enrolled on the voter rolls. invited a last question. Are there any questions after the last question? Well then, thank you all for coming out, and happy Constitution Day and happy Citizenship Day. And remember to exercise your right to vote, and encourage everyone you know to exercise the right to vote. And if you know those who should have a right to vote, but appear not to, see that they do have the right to vote and exercise that.